I'm giving an extempore judgment herein. The applicant herein seeks an urgent interim interdict to broadcast the series Queen Modjadji, which is scheduled to commence on Sunday, 14 July 2024 at 2000 hours on the Mzansi Magic Channel. The urgency of the application was argued before me this morning. Rule 612 provides inter alia that the court may dispose of urgent applications at such time and place and in such manner and in accordance with such procedure as to it seems meet. The circumstances that an applicant averse renders a matter urgent and the reason why he claims that he could not be afforded substantial redress at the hearing in due course must, in terms of Rule 612 sub B, be set forth explicitly in the supporting affidavit. And I refer to IL and B Marco Caterers versus Greitermans, South Africa 1981, brackets 4 SA 108, brackets C at 110. The requirements under Rule 612B are peremptory and mere lip service will not suffice. Luna Meubel Vervaardigers Eiendomsbeperk versus Markin and another, trading as Markin's Furniture Manufacturers 1977, brackets 4, SA 135, brackets W at 137 F2G. A proper explanation must be provided as to why an applicant should be regarded preferential treatment to be heard in the urgent court as opposed to having to join the queue in the normal course of the motion court. The general practice in this division is that all urgent applications must be properly enrolled by Thursday 12 o'clock for hearing on the coming Tuesday at 10 o'clock. This is what is referred to as a normal urgent application. To be ready, all papers must have been exchanged and same should be properly indexed and paginated. There is also a provision for extreme urgent applications, where the application is of such a nature that there cannot be compliance with the directive that all papers should be ready by 12 on the Thursday preceding the hearing on the Tuesday. One of the key urgency requirements is for an applicant to make out the case that such an applicant will not obtain substantial redress in due course. In this regard, it was stated by Tuchten J in Mogalakwena Municipality versus Provincial Executive Council, Limpopo, 2016, brackets 4, SA 99, brackets GP, at paragraph 64, and I quote, "It seems to me that when urgency is an issue, the primary investigation should be to determine whether the applicant will be afforded substantial redress at the hearing in due course. If the applicant cannot establish prejudice in this sense, the application cannot be urgent. Once such prejudice is established, other factors come into consideration. These factors include, in brackets but are not limited to, close brackets, whether the respondents can adequately present their case in the time available between the notice of the application to them and the actual hearing, other prejudice to the respondents and the administration of justice, the strength of the case made by the applicant, and any delay by the applicant in asserting its rights. This last factor is often called, usually by counsel acting for respondents, self-created urgency. Apart from the absence of substantial redress in due course, the applicants need to explain why the applications are urgent and why same should be entertained in the urgent court. Where an applicant sits on its hands or takes its time to bring an urgent application, such urgency is self-created, unless an acceptable explanation is provided for a full period applicable to the urgency of the application. See in this instance Roots, Nomino Officio and another versus SP Guarantee Company, Pty Limited and others, case number 36515 of 2021, delivered on 6 October 2022. Litigants cannot ignore pending infringements in the hope that it will not be implemented, and then, when reality knocks on the door, rush to the urgent court for relief. Where an application has become urgent owing to circumstances for which the applicant is to blame, the court should not assist such an applicant with urgent relief. See in this instance Swazi Reneke Vleismaatskappy EDMS WPK versus die Minister van Landbou en andere 1971 brackets 1 PHF11 brackets T. Self-created urgency should not be countenanced. In this instance, Black Sash Trust versus Minister of Social Development and others, in brackets Freedom Under Law Intervening, close brackets 2017, back brackets 3, SA 335 Constitutional Court. In the application before me, the applicants have failed to adequately explain or provide grounds to justify a deviation from the requirements of extreme urgency. Even if the application is to be treated as a normal urgent application, this court struggles to accept that the applicants were not sitting on their hands whilst this whole production of the upcoming series took place. Of importance is a letter dated 1 March 2024, wherein the applicant's attorney already refers to the imminent broadcasting of the documentary series and seeks an undertaking that same be stayed pending requested consultation. Absent such undertaking, urgent legal action was threatened. The applicants then waited until 28 June 2024 to consult with their counsel and to launch this urgent application. In the answering affidavit, reference is also made to the involvement of Dr. Modjadji, in submissions before court referred to as Professor Modjadji, from as early as June and July 2023, and the involvement of Dr. Posa in February 2024. The answering affidavit is replete of reference to the publication and awareness campaign launched with regard to the series. The applicants elected not to deliver a replying affidavit, and as such, this court is bound to accept the version of the first and second respondent on all of these events. The inexplicable question that is asked by this court is why the applicants did not, as soon as they became aware of the production, took any steps to halt the production. Even more so, as counsel for the applicants contended, where the application is of great cultural, constitutional and public significance. Instead, they waited until production was completed to rush to court on the 11th hour to halt the broadcast. It is as if the applicants noted that their house was burning, but only elected to attempt to douse the fire once the roof caught alight. From the answering affidavit, and once again this must be accepted as there is no replying affidavit, the series is a work of fiction set many years ago. Each of the episodes will start with the wording, in inverted commas, historical drama inspired by true events, close. Again, it is difficult to comprehend how the legacy, dignity or rights of the applicants, and more specifically the first applicant, will be infringed on by this work of fiction. In amplification, and this is just a prima facie view of this court, I am not convinced that the applicants would be successful on the merits of the application. It is thus difficult to comprehend what substantial redress the applicants would want to seek. In the premises, the application is to be struck from the roll due to lack of urgency. On the aspect of costs, on the applicant's motivation to launch the application, I deem it appropriate that there shall be no order as to costs. In the premises, the following order is made. 1, the application is struck due to lack of urgency. 2, there shall be no order as to costs. That is the judgment. Thank you. Both teams are then excused. I think just for the sake of the media and the public and council to leave court, I will adjourn my court for 5 minutes.
Court is adjourned.